Yeah.
Just one moment.
I'm sorry.
That's all right. Okay.
Yes, and I think we might want to run that. We're still well ahead of schedule.
I was going to start out with that, with the good news. Lead off with the good news is what I was going to do, that we're ahead of schedule.
Your Honor, we've agreed to the following language. Mr. Jones testified on direct examination yesterday with the expectation.
Is this written out, so is it legible?
Good luck with that.
I can make it legible.
No, that's all right. I can just go ahead.
Mr. Jones has chosen not to. Let me begin again. Mr. Jones testified on direct examination yesterday with the expectation that his cross-examination would commence today. This morning,
Or just a little slower.
Yep.
Sorry. So far, I'm in agreement.
Should I
Okay.
continue?
Yep.
This morning, the defense decided not to cross-examine him. As a result of this decision.
Just hold on.
Yep.
I'm going to add in which is their right, okay?
Yes.
So this morning, the defense decided not to cross-examine him, which is their right, okay?
There's an additional issue.
The next sentence would be, the defense expects to call Mr. Jones in its case next week. As a result of this decision,
Let me write it down. All right, as a result, go ahead.
As a result of this decision, there will be no testimony today. I mean, if you'd like to add.
Just no evidence today is what I'm saying, okay. All right, so I just want to circle back to, do you have any suggestions, Attorney Pattis, on the issue of your client calling on the jury to do research? Do you know anything about that, or do you not even know anything about that? I know.
I don't. I didn't watch the press conference, didn't attend it. I knew it was taking place. I knew that Mr. Jones intended to speak to the press. I didn't script or advise or not advise, but you can imagine that a cautious lawyer might say that his client might not want to, especially after having had some of the disciplinary rulings here. From the dozens and dozens and dozens of criminal cases I've been involved in, every time I've complained about something with the jury, I'm reminded by a court that the properly instructed jury is presumed to follow the law, and absent some showing that that presumption has been rebutted, I don't think the court should act. I understand Attorney Maddie's concern. Frankly, the thing that is most troubling to me about the representations made in court is that counsel and their families were mentioned.
Well, I was going to get to that.
And may we approach on
Yeah,
that?
no, I'm going to do everything on the record, but on this issue. But the only thing I would say about your prior experience, and I understand that, but this is not the typical case. I think we can all agree, and that this particular defendant has a platform that probably no other clients have had. So it's just. Let me just finish.
I cut you off. I'm sorry.
Yeah. So it's just. I've not been in a situation where a defendant who has a platform like this defendant has had a press conference on the courthouse stairs calling upon the jury to violate. If it's true, no, I don't know. I'm just.
I'll accept it as true because I respect Attorney Maddie as a fellow all through the court. The only other case, Judge, that actually has attracted the amount of personal scorn, death threats, and animosity toward me in Connecticut was the Tony Moreno case where the 7-month-old child was thrown off of a bridge. And the level of, and it was also televised, it was widely covered, and there was enormous hostility. And I had concerns about coverage, especially given some of the jury's presence covered hearings that took place and were televised. And I would ask the court repeatedly for canvasses of the jury to make sure they hadn't seen anything. And that was the answer. So I would say that while Mr. Jones's platform is sui generis with respect to its national reach, I think the Moreno case was equivalent in public interest in Connecticut and the hostility that it generated.
Right, and the hostility is a different issue. It's just unusual to have someone with a platform that is putting out the message, if it's true, and I haven't seen it, encouraging the jurors to violate the oath by doing independent research. And I'm not suggesting, I think we have a very conscientious jury. They are here early for every time they need to return to court. But my concern is that someone else, they're not watching the news, but someone, their family or their friends, hears that they can do independent research and approaches a juror. So I'm wondering if you have any suggestions, or if you think it's, in your own opinion, no need to do anything.
I'm an advocate. I don't want to alert them to it. On the other hand, Judge, I recognize and respect the court's inherent authority to see that justice is done, and I believe this is a discretionary call, and I'll defer to the court. I don't believe it's necessary, but I'll defer to the court.
Attorney Mahdi? I don't know if you have anything to add upon this issue, and then I just wanted to touch upon, because I was concerned, and I don't have any details at all, but I just want to make sure we don't have any issues with respect to the families or the lawyers. We've been down this road before with the lawyers, and it was an unpleasant road to be on.
We don't want to make an issue of that, Your Honor. I just wanted to...
Well, you may not want to make an issue of it, but this is, at the end of the day, my courtroom, and I have to accept responsibility. So if there are issues, I want to know about them.
What I would suggest, Your Honor, is that you give the jury the normal instruction that you give them every day. We would like to take the lunch break and come back after lunch to present any arguments we may have concerning the appropriate remedy or relief here.
We're gonna need to do it before the lunch break, so I'm happy to take another break to give you all some time to think about it, and also we need to address the issue on the charge, unless you've already addressed that.
I don't know about that.
We don't have agreement on that, Your Honor. We would need to present that.
Okay. All right, so do you want, I suppose I can bring the
Let the panel go. You can let the jury
panel down now and let them go. Okay. So Ron, whenever you're ready, please. Good morning. It's still morning. Good morning, good morning. Hello, everyone. You can have a seat, but don't get too comfortable, and I'll tell you why in a minute. Everyone can be seated. Council stipulate that our entire panel has returned.
Yes, you.
All right, you'll see we're not handing out the notebooks, so I have some information to give you. So let me start off with the good news. It's always good to lead with the good news. We're ahead of schedule on the trial. When we, it's always hard. It's more of an art than a science, but it's always hard to pinpoint exactly how long the trial is going to go. And I know we told most of you that it could go into late October. We are actually sort of ahead of schedule. So I can tell you that the case will end at the latest mid-October. So those of you who need to make plans for vacations or work or anything, you can plan about that. Now, you will recall yesterday that Mr. Jones testified on direct examination, and our expectation was that the cross-examination would commence today. This morning, the defense decided not to cross-examine him, which is their right, and you should not place any blame on anyone for that. The defense does expect to call Mr. Jones in its case at the end of next week. So as a result, there is no evidence that's lined up for today. We have business to do, and we have no evidence to present to you, so we are going to let you go early. I'm sorry, if we had known ahead of time, of course, we would have let you know yesterday so that you could have gone to work or whatever, but I hope that you will continue to be patient with us, because all of us are doing the best that we can to make this as efficient and pleasant as possible for all of you. Now, I have a couple important things to say, and I know I'm repetitive with this, but it's because it's so vitally and crucially important. You're not to do any independent research with respect to anything you've heard. If anyone in your lives, family, friend, whatever, approaches you and says, you actually can do independent research, I am here to tell you that you may not. And as I said, you can't Google a single name, you can't look anything up. So if you are approached by anyone who suggests, oh, that's not the case, I'm here to tell you that it is. So you do need to follow my instructions that regard, and I am actually very confident that you will. You're a very conscientious jury, you're here early, so I don't have any worries about that. It is also vitally important that you continue to avoid any media coverage, which might not be easy, but if you come upon it, you immediately have to turn the page or turn the channel or swipe the screen or whatever it is that you need to do. And also, just as importantly, especially on certain days, you're going to see more press than you would normally see, and you might even see some press conferences. Steer clear, because we do not want you to overhear anything at all that would jeopardize your ability to serve, okay? So there were no notes today, which is wonderful. But if there needs to be a note to Mr. Ferraro where you were unable to avoid either the media coverage or anything else, that's okay, and we will be prepared to hear it, because we do need to know if there are any issues at all, okay? So with that, I am going to let you go for the long weekend. We will pick up with you again next Tuesday. We're going to start right at 10 o'clock, and we will have a full day. Again, I apologize for bringing you in today, but hopefully you can enjoy an early start to the weekend, and hopefully the weather is going to be nice this weekend. Is it cool? Yeah, it was chilly today. All right, folks, so we are going to stay on the record. We're going to let you go, and we will see you Tuesday, okay? Stay safe. So what do you need, like 15 minutes?
Your Honor,
You can be
my
seated.
preference, Your Honor, if we could, would be to take up the issues that concern the press conference, which we need to talk about. So we need to go on break to do that, and the charge we could take up this afternoon if we have time, but we could also take it up
Yeah, I'm gonna,
Tuesday
now that
morning,
we're
so-
not gonna be in session this afternoon, we're
Right.
gonna deal with all our issues before lunch. I'm sure, that'll give everybody opportunity to get back to their offices and do what they need to do.
Judge, I run the report, I'm not going back to my office.
Beg your pardon?
I'm not going back.
Okay, well, wherever you're going. All right, so we have to discuss the issue about the press conference, is that what you want? And then the issue,
What we'd like to do is take some time, we need to talk internally about how we're gonna respond to that. So we need to
is
go
it
on.
something that the court needs to be involved in?
This discussion, no.
No, I mean, after your discussion, what is the end result here that we're looking for?
Your Honor,
Or you want to talk about it
we don't know
first?
yet, we
Okay.
don't know yet.
Is it
Since we
something-
may be seeking relief, we would.
Is
we-
it something that, that you have that you can share with Attorney Pattis?
Not
No.
yet, Your Honor. We're responding to things that are happening, in real time. So we need a bit more time to figure that out.
Okay. So it's 12 o'clock. Do you want to come back at 12:30? Does that sound like a plan?
Yes.
Okay, we'll see you at 12:30 then.
Thank you, Your Honor.
All right.
Be seated.
Good afternoon, Your Honor.
Good afternoon. Okay.
Your Honor, during the break, we submitted to the court the law and crime URL for Mr. Jones' press conference that took